Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome back to Legalese 123. I'm your host, Missy K. I hope you're doing very fabulous today. Well, guess who's back? Back again. I am back. Tell your friends. So where have I been and what's been going on? Well, I did make a post, a quick little short 2-minute video of where I've been, but I'll tell you. So I went out to Idaho to go to Moscow, Idaho. Yes, that is where the unfortunate incident of the Idaho 4 murders happened. I lived there just before it happened. I had returned just after it happened, and I went back. So I am a knitting person, as you can see, and some of the girlies that I had a great connection with have a retreat every year. We go up to the Palouse Divide Lodge, just north of Moscow, and we sit around and eat, and we drink, and we talk, catch up, knit, learn techniques, we spin, we do all the fibery things. No, I don't, I just knit, but other people spin and do fibery things. Some people do needlepoint. It doesn't matter. It is a crafting frenzy, and we just stay there, and we get 2 meals provided to us, and it's just fabulous. And then we bring our own foods and snacks and stuff, and it's lovely, and there's nobody there. We were in the middle of the forest. The weather was also extremely warm. It was like in the 40s, 50s, 60s, just amazing. So it was great to catch up with everybody. I also said that I had a beautiful flight. Delta was amazing. My pilot on the way home, Lauren, shout out to you. You were fabulous if you're watching. So anyways, get out while you can. So I've been gone. Unfortunately, I wasn't able to stream very much or anything. The internet was intermittent at times. Plus, I just needed a small break. So what are we doing right now? Aidan Kearney had his hearing on Friday the 30th. I wasn't able to cover it, but I did watch it. Long story short, who is Aidan Kearney? Aidan Kearney is being charged with witness intimidation in some of the witnesses for the Karen Read trial. What did he do? Well, he used a bullhorn and had a protest where he went out to people's houses, marched in the streets, etc. He did call them murderers. He told them to tell the truth. And also, he did that outside of the courtroom. He did call some people, and he has a YouTube show where he went on YouTube and he would call out things, etc. Now, love him or hate him, he is quite a very strong personality, and he has said a lot of things on his shows. Is that the First Amendment? So here's where the balance is. Is it a First Amendment right to say things? And if it's not a First Amendment right, and he's calling out and he's saying these things, whether they're true or they're not, right? That's the determination. Then is it defamation? Is he saying things to people? Now, defamation is very hard, very, very hard. Is it harassment? Going on a YouTube channel and talking about somebody, is that harassment? Can they send him a cease and desist? They probably could. Did they? I don't think so. But what they did instead was they went to the district attorney's office in Norfolk County and said, do something and do something. And eventually they did. Now, I know a lot behind the scenes, and some of the things they did, I don't think are legal, but yet here we are. So this has been happening since 2023. We're in 2026 right now. Where are we at? So we were supposed to have a motion on Friday. It is the motion to disqualify Special Prosecutor Robert Cosgrove. Who's Robert Cosgrove? When Aidan Kearney was charged, they hired a special prosecutor because nobody in the Norfolk District Attorney's Office would handle this case, or they were conflicted out because of the Karen Read case. These two are very much intertwined, and anybody who says so differently is very sadly mistaken. So they had to have somebody special come in. They initially hired Ken Mello to do it, but he became very ill, so they hired Robert Cosgrove. Robert Cosgrove was a sitting judge in the Norfolk district. is no longer a sitting judge. He is retired, but now he has taken up this case. From what I heard, he is double, triple dipping. He has a retirement, he has something else, and now he's charging for doing this case against Aidan. How is this possible? I don't know. We're in the world of upside down cuckoo banana world in Norfolk County. If you don't know anything about the Karen Read case, Google it. It's too much to go into. There's been a lot of shenanigans with her case. Now there's lots of shenanigans with Aidan's case. Why is Special Prosecutor Robert Cosgrove potentially conflicted out of this case? Aidan had a relationship with a girl named Lindsay Kearney. There was a domestic violence situation in which he was being charged against her. Special Prosecutor Robert Cosgrove was also ahead of that case as well. In that, they wanted to download Lindsay's phone. Lindsay said, okay, but again, she didn't expect them to download everything. They downloaded everything. Brian Tully, who is the Massachusetts State Police officer, downloaded everything and then gave it to Aidan Kearney's defense team. A second party belonging to Aidan Kearney released all of the information from her phone. It was a lot of personal information that got released out to the world. Long story short, the domestic violence case got null processed because Lindsay Kearney sued Special Prosecutor Cosgrove, Tully, and a couple of other people. She sued because her civil rights, she feels, have been violated. Whether or not that goes through or not, it doesn't matter. What is the crux of the case is that Lindsay Kearney was given a summons by Brian Tully to appear in a federal grand jury in Aidan Kearney's case, that she was a witness to this case, the witness intimidation case, etc. And so the defense team is saying, Your Honor, on this witness intimidation case, just as the other case, Robert Cosgrove is conflicted out. Lindsay Kearney, who is a witness, is suing him. They got rid of the other case because of this. He was conflicted out. Now he's conflicted out of this one. If he gets conflicted out of this one, will they have somebody to prosecute? And that is the question. So there's a new judge in town. Judge Krupp and Judge Doolin was the one that was sort of flipping this case back and forth between the two. Finally, that has subsided, and now we have a new judge, Judge Belizos. Judge Belizos is replacing Robert Cosgrove. Now, if you don't see a conflict there, let me tell you, I do. Robert Cosgrove was the sitting judge. Now he is before Judge Belizos, who is the new sitting judge. Does that have an issue? Wait till you see this hearing and then you tell me what you think. So we're going to go ahead and get into it. Aidan Kearney is being represented by two wonderful attorneys, Tim Bradel, he has the blonde hair, and Mr. Mark Betterow, who has the darker hair. Mr. Betterow is the one that will be primarily arguing this case. So, unfortunately, when this hearing first started, Judge Belizos said, if you don't have permission to rebroadcast this, you can't play this. So we are getting this from Broken Baker, who televised it because he is in Denmark. So I think those rules don't apply to him. So thank you, Broken Baker. I will also tag him, etc. when I post these things to let him know how much we thank him. All right. So let's bring this up. I'm going to try and make this bigger. And we're going to see how this goes. Actually, let me bring me down. All right. Now you might hear Broken Baker talk. There's nothing I can do.
Counsel, please identify themselves for the record, beginning with the Commonwealth.
Good morning, Your Honor. I'm Robert Cosgrove.
Good morning, Attorney Cosgrove.
Good morning, Your Honor. Timothy Bradel on behalf of Aidan Kearney.
Good morning, Mr. Cosgrove. Mr. Bradel.
For Mr. Kearney, Mark Betterow. Good morning, Your Honor.
Good morning, Mr. Betterow. Okay. Just to be clear, we've accommodated as many people as we can in the audience. I understand there are some folks outside. The court has opened the matter to Zoom, primarily because of the weather and the parking conditions. I'm not going to say that we're going to have it on Zoom every single time, but to those who can't be in the courtroom right now, we are broadcasting by Zoom. I further note the court was prepared to come out at 9, but the delay was due to the delayed arrival of some of the counsel. So with that, I would remind all parties who are attending by Zoom that any rebroadcast, if you are not qualified under SJC Rule 1.1119, rebroadcast is prohibited. Those who are qualified and have registered are certainly free to rebroadcast as appropriate. So with that, my intention today is to cover papers 110, 117 in part, 125, and 127. Those are the matters which deal with the request for the recusal or removal of Mr. Cosgrove as counsel for the Commonwealth. Now, before we begin that, particularly Mr. Bettero, just to you, and I know Judge Doolin may have talked to you about this a little bit. Going forward, we don't file affidavits as motions. Rule 13 requires a motion to be a motion. It can be supported by a memorandum of law, it can be supported by an affidavit. The matter we're here for today, there is in fact no motion on file. I'll take it as it sits because it's been responded to. But going forward, if you want to file a motion, it has to be a motion. It has to be clearly captioned as to what you're looking for. Further, it has to deal with one subject at a time. I'm not going to do motions that deal with the entire kitchen sink. It's going to be one motion at a time. It's going to be clearly noted. If you want to put a memorandum of law, again, you have to reference the motion you're dealing with. Further, if you want to put an affidavit, the affidavit has to reference the motion that you've filed. If you want to put in a supplemental motion or a supplemental memorandum, it has to list the paper number that you're talking about. Going through this over the last several days and trying to figure out what I'm dealing with took an amount of time, which is kind of absurd because I'm trying to trace back what you're talking about and I can't find the motion.
Right. So if you've been with me, you can go back to the Aidan Kearney playlist. You can see all of the motions and stuff that we've been reading. And it's like tattling on one another. Your Honor, such and such person said this, and this person said that, and la 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 la. And here's some cases, and we believe this, and they believe that. And there's been, again, not that I love a good motion because the motions in limine are the tea, and that's where we get all of the good stuff. And believe me, Mark Bretterow has served it up, and the writing is fabulous. Mark Bretterow, fabulous. Mr. Cosgrove has come back with some hits as well. But it's been fabulous. I love it. But this judge is just coming in and he's going back to, the Stone Age, right? To get up to speed on this case. And he's like, what's what and what's what? I don't blame him. But Mr. Bretterow got a little bit of a spank in there to make sure that he does what he's supposed to do and that he is supposed to be filing motions instead of just anything he wants.
It doesn't exist. So I understand you're not local to Massachusetts. Mr. Bradel is extremely experienced and quite good at drafting these things. So
because I was going to say that's my fault. I'm local counsel. I should have made sure that was that way, and we'll make sure that going forward.
And I note that paper number.
Mr. Bradel, we appreciate you falling on the sword for this one. You go ahead and take that. There have been a couple of instances you'll see, like in the Karen Reed case, etc., where Alan Jackson, he is a California attorney and he was pro hoc viced in under David Yannetti, and David has fallen on the sword for Mr. Jackson a few times, as well as Mr. Alessi. Mr. Alessi came to Mr. Jackson's rescue as well. Not that they did anything wrong, but the court was like, you're not from here. You're from, well, not New York City, but I remember the one time somebody was like, you got these New York City judges or New York City lawyers. I think that was in Texas, or sorry, in New Mexico. I think it was in the Alec Baldwin trial for Rust, where she said, you got those lawyers from New York City. Anyways, let's continue.
127 is more in the form that we used to in this court. So I just want to remind everybody where we're at. And again, not familiar with the area, that's okay. Just going forward, I don't want to have to sort of parse through what we're dealing with, nor do I want to have to hear from Mr. Cosgrove saying there's no motion filed, because it's a pretty good point on his part. So with that, let's take up the matters that are before the court. You're the moving party. I don't know who wants to argue, Mr. Bradle or Mr. Betterow?
Mr. Betterow, Your Honor.
We'll hear from you.
Mr. Betterow.
Understand, I've looked at all your motions as well as all of the exhibits.
May I, Your Honor?
You may.
Counsel states that a recent conflict of interest has developed, which ethically precludes him from continuing to prosecute matters in which Lindsay Gaetani is an alleged victim or party. Those are the words of Mr. Cosgrove on September 24th, 2025, regarding his request to be removed from another indictment in which Lindsay Gaetani was a witness, and we'll get to in this argument why she may very well be a witness in this case.
Witness is different from victim, correct?
I'm sorry?
Witness is different from victim, right?
Of course. But as we'll get to, Your Honor, if a prosecutor or anyone has a personal interest that may differ from Commonwealth's or to a defendant's right to a fair trial, that's something that has to be factored in. The point of that comment, Your Honor, is that Mr. Cosgrove acknowledged that there was a conflict arising out of Ms. Gaetani's claims against him. She has accused him of unprofessional and unethical conduct and has sued him. He draws the line.
I note that the last docket entry in that case was in the process of being settled. That's paper number 15 in that case. That was filed just last week.
Judge, whether the civil case continues or not isn't even necessarily the issue.
Explain why that would not be a problem.
Okay, I have to explain this at the top. So what happened was Melanie Little, she is a New York civil attorney. She does a lot of streaming and does a great job with a whole bunch of stuff. Hope to be her one day, right? Ha, 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 ha. She would to go stream this just like pretty much everybody else you see at the top there. And when he said, if you do not have if you're not a registered rebroadcaster, then you can't broadcast the stream is basically what he was saying. So if by chance any of these other people broadcast and they're in the United States, they shouldn't be. Whether they did or they didn't, I don't know. But remember, Broken Baker's in Denmark, so perhaps these rules don't apply to him. So just as I am streaming here like this, Melanie did that. She was streaming via Broken Baker's stream, and so he made a little nice thing at the top. So
because she has accused him, a lawyer, a former judge, of unethical behavior, and he has a personal interest, understandably so, in defending himself against that. And in any matter in which her credibility becomes an issue, as she testifies in a trial, he has an interest in discrediting her, which may be very different from the Commonwealth's interest, which I'll get into as to why that may be. But the point is, calling her an alleged victim and that there is a conflict because of her allegations against me, merely being a witness in a case in which she may testify, as the difference which somehow makes his personal interest, acting both as a criminal prosecutor while serving as a civil defendant and potentially cross-examining your civil accuser and your lead detective, is a civil co-defendant who has also been accused of misconduct, undermines the public confidence in the proceedings and demonstrates that a prosecutor could have a personal interest. The bottom line, Your Honor, the difference between witness and alleged victim is a distinction without a difference if the prosecutor has a personal interest which could significantly impact his representation of a party in the case. That's the Rule 1.7 issue. Now, Mr. Cosgrove has replied that, well, we're not going to call Ms. Gaetani as a witness, and that certainly is right for the time being anyway as the prosecutor for the Commonwealth. But the defense may very well call her. Her credibility will be an issue, obviously, if she testifies in this case. At that point, having a prosecutor who's been accused.
Okay, I just want to say that if the prosecutor doesn't call Lindsay Gattani, I can guarantee you that the defense is going to call her. And if you have, obviously, if you don't know the behind the scenes situation with this, in sort of this witness intimidation stuff, etc., Jen McCabe, who is one of the persons that Aidan is being charged with intimidating, brought Lindsay Gattani on. They were trying to get Aidan Kearney thrown in jail. They did it once. That was the domestic situation that he had. He was in jail for 60 days, and then he got released, and then they kept trying to get his bail revoked because he's out on bail for this witness intimidation. He was also out on bail for the other situation. The domestic situation has been resolved. They had no prosecutor in that case, so they just dropped those charges. But he's still out on bail for this witness intimidation case. And so as he's going on his YouTube podcasts, he's, stating all of these things about these people and against these people, et cetera, et cetera, et cetera. And they brought Lindsay on to sort of help and combat give us all the tea that you can on Aidan so we can continue to try to put him in jail. And so Lindsay was very quiet for the longest time and didn't say anything or anything of that nature. And finally, she has receipts. She has all of the text messages and threads and who's done what. There's another party named Kate Peter who is trying to get Aidan. She used to work for him. She had his passwords and stuff. And so she was exposing Aidan on other fronts as well. And so there's this whole congregation of people who are totally against Aidan and want to get him. And Lindsay Gattani is sort of the middle ground between that because now she has the tea. She's spilling the tea on X, Twitter, Substack, wherever she's going to be. And also she's given some stuff to the defense. So she 100% will be called a witness for the defense. Is there a conflict? You be the judge.
Accused of misconduct, who is named as a civil defendant, attacking her credibility and attempting to defend the credibility of other witnesses whose credibility could be impeached by Ms. Gattani, is a problem. It's a problem because the jury would have a right to know what the prosecutor's interests may be. It's not.
Well, you chose not to cross-examine her.
That's a decision that has to be made by a disinterested.
What if he chooses not to cross-examine her? Right. You're going to make that call at the day of the trial?
Prosecutor.
What if you got someone else to cross-examine her?
That may or may not solve the problem. Certainly.
Who are you going to call? Ghostbusters? You already have oh my goodness. The state is already paying for the special prosecutor to be here. You're going to have another special prosecutor just to come in and go over Lindsay Gattani? What kind of world are we living in? Why? Really? Okay. Okay, Judge Belozos. This isn't going well.
It would with the direct.
And also, I don't like how he continues to interrupt Mr. Betterow.
Examination.
I'll go back a little
decision
bit.
that has to be made by a disinterested prosecutor.
What if you got someone else to cross-examine her?
That may or may not solve the problem. Certainly, it would with the direct examination of her.
But he's not going to call her. He's made that clear.
I understand that. What I'm suggesting to the court is we may very well do that.
You may, and you'd have to get permission from the court to do that because you'd have to show me that it's relevant, but that's another issue down the road.
Well, I'm going to tell you right now, respectfully, why it may be relevant beyond just the substance of her testimony. Mr. Cosgrove addressed.
I'm confused. Do we have to go through each witness and say whether or not each witness is relevant? She's not like she's an expert. Anybody else confused? Why is he coming in so, he seems like so belligerent.
The substance of her testimony as it relates to the allegations against Mr. Kearney. She also may very well be a witness who can expose bias of other important prosecution witnesses, who could expose conduct on behalf of some of those important prosecution witnesses, conduct which is not at all consistent.
Well, let's get to the nub of it, all right? Because I've read all your materials, so you don't need to repeat the argument to me. Look, as I understand the issue here, Ms. Gaetani, that's the correct pronunciation, is it not? Ms. Gaetani has an interaction with Special Prosecutor Mello in December, I think the 24th, was it, or the 23rd?
Something like that.
Of 2023.
Mm-hmm.
It's around that time that she's alleged to have some interaction with Ms. McCabe. Is that correct?
Amongst other times, yes.
Well, around that time is my understanding, based on the evidence you presented me. Around that time, Ms. McCabe urges her to go to the grand jury. Do the right thing, go to the grand jury, something along those lines. All right, is that correct?
In
Yes.
substance, but I think it's interpretational, and the witness might expand upon that.
I understand that. All of those events occurred 6 months after the events that are in play here. So the relevance of those events is only as to the credibility, potentially, of Ms. McCabe. Now, you might be able to get into that. You might be able to even confront Ms. McCabe. But then you're going to have to raise an issue of whether or not you get into a trial within a trial, so to speak, the extrinsic evidence rule, which takes us to whether or not she is even going to be a witness to talk about potential bias after the fact. This is after the fact bias.
Yeah.
Okay, I'm flabbergasted right now. Why are we going this route? Why are we talking about witnesses? We're supposed to be talking about whether or not Cosgrove can continue to be on this case. And why are we talking about whether or not things can come in or not? We're not even to trial yet. I don't like where this is going. Oh, no.
On an issue which, frankly, I'm struggling with a little bit, because nobody contests the acts here, all right? Mr. Kearney is a citizen journalist, sort of a new breed of journalist, correct? He presents to this court that all of his activities are fully protected under the First Amendment. Very reasonable argument, okay? Mr. Cosgrove says different. He says this is witness intimidation. The motivation of Ms. McCabe to his acts is tangential by and large, is it not?
Judge,
now she's going to testify, yes, I was intimidated. But the main factor here is the nature of the comment, which is recorded, made voluntarily and recorded. Now, you are correct. There's an excellent argument to be made, perhaps, that Gaetani and Genduso and McCabe may have all had some idea that they were going to get together and get his bail revoked.
Right.
But that's not what this trial's about. This trial's about what happened 6 months before. So you got
Okay, no, I disagree. I wholeheartedly disagree. She was saying that she was intimidated and that she was afraid, whatever, right? But then her actions afterwards state that she's not intimidated. And even so, the time that he had done these things, and I don't have the timeline, to when she testified in trial 1, trial 2, when does intimidation begin and when does it end? Does the intimidation happen when the first time he says something, or that he went to her house and that's when the intimidation was, and therefore he intimidated her on that day, but then 6 months later she's not intimidated by him again? When does intimidation begin and when does it end? Is she constantly intimidated by him? This is bizarre. Okay, remember, he's a sitting judge. Now he is also in Canton judge. Now, mind you, they're in Suffolk County, Boston right now, because that's where he's sitting. But he represents Canton people. And this is where Karen Reed was tried. This is where all of the shenanigans happened. This is not looking good.
to draw me to the relevance of that.
Well, her bias and motive against him, whether before, during, or after, I would suggest is certainly relevant. Moreover,
But it's all after. There's no before.
Judge, you mentioned a moment ago about the fact that she's going to come in and say, I felt intimidated or I was emotionally harmed. I think we would all agree that would be relevant about what the impact that these horrible allegations had on her. There will be evidence through electronic communications between Gaetani and McCabe, which Gaetani may very well have to authenticate as a witness, because frankly, we don't assume or take any guess what Ms. McCabe will say, where shortly after Mr. Kearney was released from jail, from what Your Honor just spoke about, where Ms. McCabe recruited Ms. Gaetani and orchestrated surveilling him from various police stations and to other locations, joking about going on a stakeout. In other words, conduct not consistent with her being intimidated. Those actions will also
the intimidation doesn't have to last forever. The intimidation, we're only trying one slice in time. That's the bedrock of any criminal defendant, right? But not trying his entire life, we're trying that moment.
But these are questions that have to be posed to Ms. McCabe, and she'll have and should be forced to answer them and explain them.
I don't necessarily disagree with that.
Okay, so the point is, we don't know what Ms. McCabe will say. We know based upon messages that we've seen, which would need to be authenticated, presumably what Ms. Gaetani will say about these issues.
Which seems to move with time from poll to poll, correct?
I'm not sure what you mean.
Well, it seems like her allegiances have changed as this case has developed.
She is, without question, a unique witness, which raises another interesting point, which could lead to the possible conflict with Mr. Cosgrove. She is a former prosecution witness. There's no question. She testified in grand jury. She testified at a trial called and vouched for by Mr. Cosgrove.
Quite enthusiastically, as I understand.
I believe so, Judge. No question. And at that point, they had no problem with Ms. Gaetani. But at this point, she's now sued Mr. Cosgrove. She has sued Tully. She has threatened to sue or sent a demand letter to the DA's office. And when that happened, Mr. Cosgrove said, I have a conflict with her because he has a personal interest in seeing her discredited. And I'm going back to what I first started with, Your Honor. The issue is not because she's an alleged victim. She's a potential witness in this case, and the prosecutor has a personal interest in seeing her discredited. And the critical part comes in the argument to the jury at the end of the trial.
Right. It's not just that. It's not just, okay, so let's just say she becomes a witness, right? She is suing him. Now, you can't really sue a special prosecutor. They're exempt. They'll get into that later. But she's going to be on the stand. And prior to this, in one of the filings, we went over it. When Cosgrove responded to Bettero's filing, he basically lambasted Gaetani, told her she better go get herself her own lawyer, and that he slut-shamed her. And in a public filing, it was very disparaging, and I couldn't believe it. And if he would go to lengths, Cosgrove, he would go to lengths in this filing, public filing. Who knows what is going to happen when she gets on the stand? Now, I can kind of see the judge's point that, hey, listen, her lawsuit against him isn't going to go anywhere, and that probably will be resolved before this gets resolved. But I don't know. I just don't know.
Trial. When McCabe has testified, it's in Mr. Cosgrove's personal interest that she be credited, Gaetani not be credited. When Tully testifies, it's the same exercise. He's a co-defendant of his.
What's Tully going to testify to?
Is Tully going to testify? We're not calling Tully.
Mr. Cosgrove, what's Tully going to testify to? Is he even a witness?
I am in determination as to whether I'm going to call Lieutenant Tully or whether I'll need to call Lieutenant Tully. It seems to me that the videos which Mr. Kearney has himself made public, documenting his statements and actions are pretty much self-authenticating. not sure.
Well, I think you may have to make a choice here fairly quick if we're going to deal with this issue.
What's fairly quick, Judge? What's fairly quick? Are we rushing into something here? Tell us how you really feel.
Continue.
Look, the bottom line is Detective Lieutenant Tully is the lead investigator on this matter. Now, that doesn't obligate the Commonwealth to call him, but he is the driving force behind this. He built the investigation. He got the search warrant.
Mr. Better, this is not your classic whodunit.
No,
This is not the investigation where they find evidence on a scene, they develop the evidence on the scene, they trace the suspects, they get phone downloads, they do this, that, the other. This is a very unique set of facts. Where the defendant recorded himself and then voluntarily broadcast his actions to the world at large. So the investigation essentially is press record.
Okay, I have issue with that. He didn't broadcast himself to the world at large. He broadcasted, and then you, as the viewer, get to choose whether or not you want to see it or not. It's not television. It's not live. It's live on YouTube, but it's not. It's you have to go on there and have to click on it. Well, you're going to get into semantics. Let's get into semantics.
Court, and then voluntarily broadcast his actions to the world at large. So the investigation essentially is press record, and then a jury of his peers, all right, would judge the mores of our society to determine whether or not this is acceptable First Amendment or not acceptable First Amendment.
the point I'm making, Your Honor, is
Oh, okay. So what was that statement? That this is going to trial and that he's letting the jury, he's going to get the people of Norfolk County to decide whether or not this is harassment or not. You may not know, but they have several other motions pending before this court, and one of them is the motion to dismiss outright. Sounds like you lost that motion before you even started. This is not good. I'm going to back it up just a second.
A jury of his peers, all right, would judge the mores of our society to determine whether or not this is acceptable First Amendment or not acceptable First Amendment.
the point I'm making, Your Honor, is
Did he even get there?
And I would like the jury of peers to make that decision. I don't want to make it. I want the jury of his peers to make that decision.
No. I don't want to make that decision. I want the jury to make the decision. Oh, this is not going well, Aidan. I'm so sorry. Oh, no. This judge just said, I don't think he meant to say that. So he's already decided before coming on this bench that he doesn't think that Cosgrove is conflicted and that this needs to go to trial. Wow. Why? Wow, look at Aidan's. Oh, you can't see Aidan's face. Look at Aidan's face. He's like, this isn't going well. It's not. I'm going to back it up just a minute so you can hear this. For those of you at home.
To determine whether or not this is acceptable First Amendment or not acceptable First Amendment.
the point I'm making, Your Honor, is that Tully.
And I would like the jury of peers to make that decision. I don't want to make it. I want the jury of his peers to make that decision.
I don't want to make it. I don't want to make this decision. I'm sorry, Mr. Judge Belazos, with all due respect. You chose to be a judge. You're going to have to make decisions based upon the motions that are in front of you. and you're constantly discrediting everything that Mr. Betterow is saying and constantly cutting him off. He's not able to make an argument. Oh dear. Oh dear. This is, I just need to shut up. Keep playing this.
Point I'm making, Your Honor, is on this issue is that Tully is the lead investigator. And certainly I can only speak from my own experience, perhaps others, that it would be extraordinarily rare not to call.
I don't find that to be accurate in my experience. I've seen it happen a number of times, much to my disappointment when I sat over there, okay?
I've seen it happen, and I've taken that from the other side of the table in prosecuting rather than defending, in letting.
I wonder if this judge is upset at Mr. Betterow for making him have to read all of those papers. And that since he didn't file things correctly in Massachusetts, that he is, besides getting a tongue lashing, he is also giving him the judgitude. That's what I'm going to call it, the judgitude. It's the judgitude of, you don't know what you're talking about, Mr. Betterow, and I do. Because he used to be a defense attorney, Judge Belazos, and he was sitting in these courtrooms going against well, I don't think he said he went over Cosgrove very much, but I think he did some things in front of Cosgrove. Oh, this is not going well.
Juries know who built the case, what is going on here. But the point,
and fairly pointed out by the defense, and you didn't hear from him.
It could be. It may very well be, but that could also lead to the reason why. Okay, the issues surrounding Gaetani's claims, the defense wants to argue they're not calling Tully. Perhaps the jury may be entitled, not asking Your Honor to make evidentiary rulings now, obviously, but the jury may want to know and be entitled to know why isn't the prosecutor calling him, and might it have something to do with what Gaetani alleges. But moving away from Tully to the larger point, it's not even so much the cross-examinations, or other evidence, which I would suggest are improper being conducted by a prosecutor with a personal interest in favoring certain witnesses over the one that is suing him. It's the summations, it's the argument. Mr. Cosgrove.
Okay, Mr. Betterow, I saw the comment that this person made, and it's a good comment. Are we arguing the motion to dismiss and or what evidentiary things are coming in and what witnesses are coming in? Or are we arguing that Cosgrove needs to be taken off of this case? We are conflating three different things in one fell swoop. And I feel like we are just not good and we're not getting anywhere. I don't know what is going on.
Has an opportunity to cross-examine Ms. Gaetani, assuming he does, as Your Honor noted, maybe he won't, but I would suggest, again, that's a decision to be made by a disinterested prosecutor, not one with a personal interest.
Well, let's define the personal interest. It is, anybody can bring a lawsuit against anybody, all right? You know, the actions that are alleged here by Mr. Cosgrove, and most of them appear, frankly, seem to have occurred prior to his arrival in the case. But the actions are alleged.
True.
Were done solely in his role as a special prosecutor. You know, his immunity is almost impenetrable, correct?
In a legal sense.
Sir, this is a legal setting.
No, Your Honor, my point is this. Personal interests don't rise and fall. They're not black and white because you've been sued or not sued. She has publicly and loudly accused a distinguished prosecutor of misconduct that he himself recognized after the lawsuit was filed. This lawsuit that we're saying has no merit. What did he do? He sought removal because I'm ethically precluded from cross-examining her. It's the same issue.
Well, I'm not sure about that. I'm not sure that's what he said, but I'll take that for what it is.
Well, Judge, I just want the record to be clear. What he said was, counsel states that a recent conflict of interest has developed which ethically precludes him from continuing to prosecute matters when Gaetani is an alleged victim or party, and we talked about whether we use alleged victim or witness. as the issue. The point is,
Well, that's why I say that's not exactly what he said. What he said was,
yes, no,
Art.
I'm not trying to substitute that. We're having, trying to, in my view, suggest it's a distinction without a difference, because he has been attacked. And when he withdrew from the other case, the lawsuit against him was no better or no worse than it is now. So he didn't make that argument back then to say, this is some garbage lawsuit, I have no real conflict. What he said was, I am ethically precluded.
all right, I take your point. Mr. Cosgrove, if you're ethically precluded from one, why aren't you ethically precluded?
Okay. If any of you know Mr. Cosgrove talks at the most slightest snail's pace. And so, therefore, we have the opportunity to amplify this up. So we're going to go at higher zoom speed. So just a moment here while I zoom him up, because man, oh man, oh man, oh man, you're going to thank me. You're going to thank me. You're going to thank me. Now, mind you, everything else might go, but it'll be okay. It'll be just fine. Be just fine. All right, let's bring it back up.
I'll come back to this issue of the 2025 investigation too.
I reserve my answer on that,
Reserve it for when?
when it's my turn to speak.
I was about to give you your turn to speak, but I'll go back to Mr. Bedero. Let's talk about the 2025 investigation.
Your Honor, can I make one point I didn't get to? We kind of
Sure.
got.
Okay, hold on. Whoopsie, because Mr. Bedero, holy smokes, that man can talk really fast, and I appreciate that. But if we can't hear him, we're gonna have a problem.
The summations where the real problem arises here, because if Gaetani were cross-examined by Mr. Cosgrove, in essence, it is almost a free deposition. It is sworn testimony of her
Sure.
by a litigant against
Yep.
another litigant in a civil matter in which he has the full power of the government cross-examining, which will benefit his personal interest. Then you go to
Yep.
summation. Presumably, his argument will be Gaetani is not believable, Gaetani is not credible, but McCabe is. Now, those are appropriate arguments by most people to make, not him, because it is in his personal interest, not just as a representative of the Commonwealth. It is in his personal interest that she be discredited. And the jury should know that. Now, I'm not saying that's an appropriate outcome either. The appropriate outcome is that he be removed, because if he's vouching for the credibility, not in an illegal sense, but advocating for the jury to adopt Jen McCabe and discredit Lindsay Gaetani, the jury should not be ignorant to the fact that this guy's getting sued and wants her to be discredited. That is not the kind of thing that the public can have confidence in when they find out that the prosecutor who is judging everyone's credibility is discrediting her, crediting another, and it's tantamount to him giving unsworn
But
testimony.
this goes back to the issue of relevance that we talked about before. And this is where I'm a little bit hung up. What McCabe does 6, 8, 10 months after the allegations here, because the allegations with regard to McCabe, as I can tell, they occur on 6/6, 9/20, and 7/22. Those are the 3 dates where she's alleged to have been intimidated. So none of these matters involving Gaetani develop until perhaps December, right?
Some of her testimony, though, Judge, will corroborate other evidence we have of Jen McCabe's pattern of surveilling Mr. Kearney.
But when
before he was indicted.
But when?
In 2023, July of 2023. We have documented evidence of her, the intimidated and emotionally harmed witness, contacting Mr. Kearney on social media and alluding to the fact, I know where you are, which is exactly what we're talking about with Gaetani.
That's a fair point to cross-examine her on, no doubt.
Don't know what she's going to say. From our perspective, having seen some of her other testimony and other proceedings, We don't just assume that she's going to be forthright. And we have a right. She's the star witness of this case.
I may need to know a little bit more about that. In terms of, if you want to file something impounded to me, that's fine.
The final point I'll make, to Your Honor, before you have any other questions, is it's important that we're raising.
Why are we talking about this now? What? Send me something impounded. You just admonished him earlier about filing motions and stuff. Why are we impounding? Excuse me. Why are we impounding things at this moment when we're the issue at hand is Robert Cosgrove going to be kicked off of this case? We are all over the map here, and I don't know what to do. I'm so confused. Are you confused? I'm confused.
This now. This is well before trial. The prosecution is clearly on notice. I don't know where this may lead to, what else could be discovered. You know, this is a unique case, as you've noted, and evidence is discovered in all kinds of odd ways, believe me, with how these cases proceed and who shares what and those kinds of things. It's critical for us to make this record now, alert the court respectfully.
I have no issue with you making a record.
Because if it comes up later after a jury is impaneled, there is a risk of a mistrial, and that will not be our fault.
Yeah.
And we think at that point.
Listen, Ms. Bitter, I have no issue with you bringing the motion. You're supposed to. You need to advocate for your client in any way you think is appropriate. I'm just trying to flesh it out here, so I understand exactly what the issues are. I'm struggling with the relevance issues. You may have to give me more information on that, so I understand it a little bit better, because the way I read things, they're much later in time. Now, if you've got something that's more contemporaneous to the alleged intimidation, I think that's very, very relevant.
We're all over the map here. Let's get back to the issue at
How that
hand.
would come in and what the form of that evidence. So we'll come back to that at some point when you're ready to talk to me about that. But talk to me about this. Your motion had three parts. Your affidavit had three parts, and one was the 2024. That's moved because it's already been done. The second was this issue. The third was this idea that I could preclude the executive branch from investigating things in 2025. Can you give me some authority which says I have the ability to do that?
It's a unique situation, Your Honor. I'm not going to sit here and tell you that there is a case law roadmap to what's happening, but what's important to recognize here, you've been asking us these questions about how is Gaetani relevant. She is extraordinarily relevant to what we're calling the 2025 investigation, which results in these search warrants for the phones of Karen Reed.
Which is still pending with Judge Krupp.
Right.
Let me play that out two ways.
Okay. If you don't already know, some of you may not know, when I say that Aidan Kearney and Karen Reed are intertwined, there is a magical search warrant that is still out there in the world. Karen Reed was tried twice. First one was a mistrial. Second one, she was acquitted. But there's still this search warrant out there for her phones. They're saying that she colluded with Aidan Kearney to intimidate witnesses, and that she told Aidan Kearney to intimidate witnesses or say things, etc., etc., etc. They have had her phones for a long time. They've had Aidan Kearney's phones since 2023. I think these phones that Karen Reed had, I think the two phones that they're talking about, they've had since 23 as well. We don't know if they've been downloaded. We don't know if they've been gone through. We know that the downloadable people have not been forthright and coming through with the information, because usually they download everything and then later on they get it in through fruit of the poisonous tree. So we don't know if they did or they did not download their phones. One minute they're saying we didn't, and the next minute they're saying we did. We as the public do not know. What's happening with this? There's this search warrant that's floating out there to see if they can download Karen Reed's phone and extract all the information off of it, then to get evidence of witness intimidation to then either charge her or continue to solidify the charges against Aidan Kearney. This is hanging over the both of their heads, and it's under Karen. So the silly thing is, it's under Karen Reed's case. that actually right now is nobody can look at. So we don't know what's going on with this search warrant. But we do know that Robert Cosgrove is the one going after this. What's happening with that? Judge Krupp has it under his purview. He's had it for several months now, and he's waiting. We don't know why he's waiting. Recently in December, I believe that he had moved to civil court, and he's not doing criminal courts, but he's doing some criminal courts because he's still keeping it underneath him, which is Miles King. The search warrant is hanging out there, and they'll talk about it. Robert Cosgrove is waiting to hear Judge Krupp's order on whether or not that they have the go through her phone and to see whether or not there's anything of substance, to see whether or not they can go ahead and pin more charges on her, or if they can pin more charges on Aidan or solidify the charges they currently have. What and how they're holding this over these two people's heads and what they hope to gain by that, we don't know. Let me back it up a little bit.
Which results in these search warrants for the phones of Karen Reed.
Which is still pending with Judge Krupp.
Right.
Let me play that out two ways. What if Judge Krupp says you can have access to the phones? Then we're going to have a much longer issue, correct?
Yes.
Is that going to come into this case?
Yes.
Well, they're telling us that two people are under investigation. I mean, it's hard for us to know, right? I mean, they're attempting allegedly to indict Mr. Kearney and Karen Reed for actions in which they already tried to indict and the grand jury said no. And now 2 years later with phones that have been gathering dust, we need to look in these phones and, God knows what we'll find. But the point is the search.
I failed to mention that. They already went to a grand jury to indict Karen and Aidan Kearney together, that they were colluding on witness intimidation. And the grand jury said, no way, Jose, they didn't indict. So they're holding on to the phones as some sort of leverage for something.
Warrants in that case are critical and certainly could relate to evidence used against Mr. Kearney. There are two informants in that search warrant. One of them is Lindsay Gaetani. And the affiant of that warrant is Detective Tully. And there are about 10 paragraphs, and I'm paraphrasing, I don't know the exact number.
I read the warrants.
Relying on her, and it is loaded with information which she provided them. And we're back to the personal interest of Mr. Cosgrove. So that really was meant to just inform the court that this is a living, breathing issue.
I will agree with you, it's a living, breathing issue. It's just not a living, breathing issue over which I have authority.
Fair enough.
No, but he just told you how it's intertwined and how Lindsay's intertwined in this search warrant and all these other, it's like begot this to the begot that to the fruit of the poisonous tree. It's just like, don't you see that these things are intertwined and connected? You just said that, but now you're saying no.
When that comes to me, if it comes to me, I don't know if my special assignment encompasses that. We'll see. But if it comes to me, then we'll deal with that issue. I can find nothing which gives me the authority to restrict that activity. Judge Krupp has the authority on the search warrants, and he'll make a decision in due time. But I find nothing which gives me the authority to restrict prospectively an investigation that's being done by the executive branch.
Judge, just before I sit down, and unless the court has any other questions, I just want to correct one last thing. Your Honor had mentioned about a lawsuit being settled. That is not the lawsuit involving Mr. Cosgrove. There's no.
Sure it is. I looked at the docket this morning.
Not with him. That's with other parties to the litigation, is my understanding.
Okay. Well, let me play this out for you. It's, as I said, I have some familiarity with this immunity issue since I routinely see these motions. It's a very strong motion to dismiss. If that motion is filed and heard, again, accusation is one thing, but it would seem like there's a little bit more. You'd have to have some substance to it to actually disqualify. But I'll keep an open mind on it. Anything more?
Anything else?
No, I read all your stuff.
Thank you.
Anything more?
No, sir.
Mr. Bradley, anything?
No, Judge, thank you.
Okay. Mr. Kearney, Mr. Cosgrove,
Okay, as I said, we have to change the speed for this because I just know he's going to talk and talk and talk and talk, and you will thank me.
If not, if you're conflicted out in one case, why aren't you conflicted out on the other? That's the real big question here.
Well, I don't think the two necessarily follow, Your Honor. Obviously, before I filed my motion seeking to withdraw in the other case, I would have been a poor attorney indeed if I didn't think about whether it also required me to withdraw in this case. And the motion to withdraw was, at least I attempted to phrase it quite carefully, to say that I had a conflict because Ms. Kearney was the alleged victim in that case. Not that she was a witness in that case, but that she was the alleged victim. And as we all know, Your Honor, the Commonwealth does not represent the victim. The Commonwealth represents the Commonwealth of Massachusetts. But nevertheless, it was essentially an argument that I would be making in that case, that Mr. Kearney committed crimes against Ms. Kearney. That, it seemed to me, put me in the impossible position of raising the suggestion that I was going forward to vindicate Ms. Kearney's interests, perhaps to mollify her or to persuade her to withdraw the action against me. That's not the case where she is simply a witness.
Well, what do you say to the idea that you'd want to discredit her for your own benefit if it came to trial?
Well, that's a very interesting point, Your Honor. And there's a couple of problems with it. One problem is the practical matter. I don't see how any way that I went about discrediting her testimony in this trial would spill over to the other litigation, because it
Why not?
It doesn't seem to me that it would be in any way relevant to the other litigation. I suppose I could adopt.
It may not be relevant, but when she's on the stand, you can ask her anything. And then you can discredit her on some things, and then you can bring it into the other one and say, well, she said this, Your Honor. If you don't see a conflict here, then I don't know.
The defense theory that everything is relevant to every issue, but I don't see how indicating that Ms. Kearney was not credible in making statements about the investigation of Mr. Kearney here would have any relevance to an accusation that I breached some sort of duty to her by turning over a police report, which is the contention. Also, Your Honor, assuming that this even survives a motion to dismiss, and I'm talking now about the Middlesex case, I don't think there's any factual dispute.
Worcester case, there's nothing in Middlesex, right?
I'm sorry, Worcester, yes,
Okay.
thank you,
Right.
I appreciate the correction. I don't think there's any factual dispute.
It's her civil
as to
case
what
against
happened.
him.
In my capacity as a prosecutor, I provided Mr. Bradel with the police report in question as discovery. It made its way by whatever means from Mr. Bradel to Mr. Kearney, who then publicized details of it and turned it over to a friend, an associate, whatever you want to call him, who actually put the whole report, as I understand it, on the internet and began pillaring Ms. Kearney over her credibility. I don't dispute that I turned that report over as a matter of discovery. If this case ever develops in Middlesex and comes to fruition, I couldn't possibly dispute that. That's the absolute factual truth. From that point on, it becomes a pure question of law as to whether I breached some sort of duty under the statute to Ms. Kearney under the mistaken belief that I had a Rule 14 obligation to turn this over as the statement of a witness who had testified against Mr. Kearney in another matter, and as bearing on her credibility and her possible bias. Maybe I made a mistake. Maybe I was wrong legally, but that's not a matter of discrediting her. That's a matter that is purely a question of law. And it's also not a matter.
How do we avoid the circumstance?
Right.
She's called to the stand, and there's some relevant testimony that she can offer. You wouldn't call her, but the defense calls her. And you're in the midst of cross-examining her, and she says, well, this is why I sued you. What do we do with that?
Right. Yeah, Broken
I'm not
Baker's
sure what you do with it, Your Honor.
Broken Baker's got the hands.
Maybe we deal with that with the motion in limine to preclude her from mentioning the Middlesex suit.
Doesn't sound like a terribly controllable witness.
Oh. Did you hear him? He's like, well, maybe we make a motion that says she's precluded from saying things. And the judge is like, you can't control a witness. You can't control what they're going to say on the stand. Oh my gosh, we're in clown college here.
That's why we have skillful Superior Court judges, Your Honor, if I could
You can find one.
be a little obviously self-serving in my comment. I'm sure,
Well,
Your Honor,
start giving
both
out
in
backhanded
his,
comments.
prior career, as I have in mine, and in your present position, has dealt with witnesses that are difficult to
Oh my
control.
gosh. Let's
What about the
continue
possibility
to
of someone
stroke
else
each
coming in?
other's
Is that something
egos.
that's realistic or not realistic?
I didn't quite hear you. Something else?
What about the possibility of bringing someone in to deal with Ms. Gaetano if indeed she's a witness?
So as I said earlier in the stream, he's thinking about, why don't you just go ahead and bring somebody else in just to go ahead and question her? Sure. Taxpayers of Canton, Massachusetts and the Norfolk County, get your checkbooks out.
Could be done.
Well, it would solve a lot of issues. Ms. Bedrow? I mean, you're not contending that the case goes away completely. You're contending that he can't deal with Gaetano.
Unless, Your Honor,
Gaetano.
I understand what Your Honor is saying, and it sounds at first blush that the idea that if there's some kind of ethical screen, for lack of a better term, that just keeps a separate wall between Mr. Cosgrove and Ms. Gaetani. But if the issue of the lawsuit comes out in any way, whether it goes...
Well, if he's not the one asking the question, I'd be hard-pressed to figure out why the issue of the lawsuit would come out.
Could. Again, I don't know.
But that is my job to control what comes out. But so
Yes.
Legally, let's think about it not from a witness point of view, but from a legal point of view. If Mr. Cosgrove is not the one examining the witness, I preclude that evidence because it's really not very relevant. I think we all agree.
Your Honor, I mean, look, it's certainly not for me to suggest what could happen. It's for the court to rule and the prosecutors to figure it out. I guess the first question is, why are we having this conversation? Why haven't they done that? Why is this a one-man show when this is a serious issue that there could be peril?
Well, that's why we're having this conversation.
Right.
Ahead of time, as you properly noted.
The other thing, if I could just respond briefly, I don't know if Mr. Cosgrove...
I think he's not done yet. I just was raising that one point.
I'll hold it.
Cosgrove has barely started, but go ahead.
All right. So
I barely started.
it would appear to me what you're saying to me is, if there was a replacement for that issue, that would...
Yes, another special prosecutor on top of the special prosecutor on top of the special prosecutor. Remember, I feel like the count on Sesame Street. One special prosecutor Mello. He's kind of in, he's kind of out. We're not 100% sure. Two special prosecutors. Robert Cosgrove. Three special prosecutors to just come in to question Lindsay Gaetani.
resolve this problem?
I don't know that it would. It's certainly a much more realistic situation where you could avoid, no question, having Mr. Cosgrove comment on the credibility of Ms. Gaetani.
You'd agree with me that does happen in trials, not with some frequency, but it's not unheard of for that to happen.
No, it's not unheard of at all. I mean, there are times, again, where you have a prosecutor who takes a statement of a defendant.
Sure.
They have to be a witness. These kinds of things can happen all the time.
We find ways around them.
But we're also, to be clear, we're dealing with a very rare situation where the witness is a former prosecution witness accusing the prosecutor who she testified for previously of misconduct. Now, if the prosecution and the court approves of that process, wants to have that laid bare, then I suppose it could. But the other problem,
just on this issue, we're not going to hijack the rest of the argument.
Okay,
just on the issue of replacement.
I had a brief response.
Yeah, he's not done. You only get to respond when he's done.
Yes.
Mr. Cosgrove.
Well, just on that point, I have yet to hear how any comment that I might make on the credibility of Ms. Gaetani's testimony in the case before the court would even come in or be relevant in the Middlesex case or assist me in any way. Am I going to go over to Middlesex Superior Court and, frankly, I find it hard to believe that I or whoever would be representing me would be brazen enough to say to the judge, well, I want to talk about all the ways in which my client, Mr. Cosgrove, impeached Ms. Kearney in a case that has nothing whatsoever to do with the case before the court. There's just not going to be any bleed through whatsoever, it seems to me. We don't even have, frankly, Ms. Kearney's now at the point, based on her public statements, where she has faced in so many different directions, that I find it a little difficult to believe that either the Commonwealth or the defense is going to call her in this case. Mr. Counsel has carefully said we may call her for the defense. This may be a contingency that doesn't even arise, but that's sort of a side point. Let me.
There's a lot of
just
what
make
ifs.
a couple of
What
points.
if this and what if that?
I'm going
and
to
what if
ask
this?
Your Honor to take judicial notice of the pleadings in the Middlesex case and the docket. It appears you've effectively done that, but let me make an oral motion on the record.
Any objection, Counsel?
No. Purpose.
Okay. Agreement. I'll take those as judicial notice as to the Worcester Superior Court case.
And one of the interesting, unique things about this alleged conflict of interest, which is a little different from the typical conflict of interest case, at least I haven't found anything precisely on point, and I don't think the defense has either, but maybe they'll prove me wrong in a moment, is the whole operation by which this alleged conflict has come about and the Middlesex case has come about. What is it that enables Ms. Kearney to make the claim that she's seeking to make against me in the Middlesex case? It's that defendant put the report I gave him as discovery, or I gave his counsel as discovery in the other case, publicized it, and then created harm that Ms. Kearney alleges accrued to her from that publication. In other words, if we're
True.
applying but-for causation, to sound like a tort lawyer for a minute,
Right. Yes.
if we take Mr. Kearney's actions out of the whole proceeding, there's no harm whatsoever to Ms. Kearney with my, as I see it, fulfilling my Rule 14 obligation. So Your Honor has the unusual situation here of a defendant who has been but-for.
You see, it's more than just a Rule 14 violation. It's more than a but-for violation. The initial violation was that you downloaded her entire phone, which is what you do. You did it in the Brian Walsh case. I'm sure you did it in other cases, and somehow or another, you slimely got it through the court system. And it's terrible. And so, and then people can't go back and say, well, you violated my rights because of X, Y, Z. So, not telling you how to crime better, but if they're going to take your phone because you're a recipient witness in some sort of case and they want to download and extract what you have on your phone, first of all, no thank you. And second of all, if you happen to do it, you sign a waiver that says exactly what they are allowed to extract from your phone. And still, even then, you cannot guarantee that they didn't make a whoopsie. Don't crime. Don't crime, people. Don't crime.
For cause of the alleged conflict, seeking to profit from that conflict by removing the prosecutor of his case, which I think is worth some consideration by the court. What I would like to do now, Your Honor, since the defendant has had the opportunity for a reply brief, which frankly doesn't particularly go to these motions, particularly, but more to the point, the defendant's reply in support of the motion to disqualify Robert Cosgrove. I'd like to examine that in some detail and take the opportunity to reply to some of his.
Well, it really hasn't become an issue here. That involves another party whose case has been dismissed. The case regarding the defendant and that witness is gone. That's dismissed. So I don't really know if that's all that relevant to any. Mr. Beddoe didn't even raise it.
For purposes of this, Your Honor, the briefs are what they are. We submitted them. I just raised the issues I thought would be helpful for the court today.
Yeah, I didn't find that anything with regard to that particular trooper terribly compelling because I don't understand how he would be part of this case. Fair to say?
You're talking about Which trooper?
The trooper whose case was dismissed, Bouchard.
I'm not talking about the, I'm sorry for interrupting, Your Honor. I'm not talking about the motion that they filed with respect to discovery for Mr. Proctor.
Oh, I'm not dealing with discovery right now.
I'm talking about the motion that's captioned, "Sir, reply in support of motion to disqualify Robert Cosgrove."
Paper 127 you're talking about.
I don't know the number, to be honest with you, but
Oh my gosh, the shuffling of the papers in my ears.
This one here?
yes,
Yep,
exactly.
that's 127.
Okay.
Okay, go on, I'll hear you.
So,
I am surprised that Betterow and Bradle aren't getting up and shouting from the rooftops. So, if you don't know Robert Cosgrove, when Betterow primarily is the one that's writing the motions or the affidavits or whatever in this case, when they go ahead and do this, Robert Cosgrove then is supposed to respond in his papers. And he's failed to do so. He's failed to respond, or when he does, he blows the deadline and he's like, I'll ask for forgiveness later. And this judge specifically said when he got the case earlier or late last year, he said, if you're going to respond, these are the deadlines, no ifs, ands, buts, or coconuts. And yet he's going to let him stand here and respond to this motion in court. I don't know.
the defense begins by complaining that my response envisions my conflict in a vacuum, and that it ignores the whole context, which is basically a.
Okay. I am speeding this up because I can't take it. And I hope that you appreciate it because we're going to speed this up a little bit more. Let's see what this does.
Preface, Your Honor, for talking about everything else that the defense is unhappy with about the case, except issues that are relevant to whether or not I should be disqualified. There is, on page 1 of that motion, a suggestion that Mr. Morrissey recused his office from prosecuting Mr. Kearney due to a conflict created by an investigating journalist who publicly accused the DA's office. I'm not sure that Mr. Morrissey has made a statement explaining why he appointed a special prosecutor, but
how's that relevant?
I'm ready to stand to be corrected, but certainly this is the explanation that might sound most favorable to the defendant. But what does it have to do with disqualifying me?
What does it have to do
He then
with
talks about
what now?
accusations against Lieutenant Tully and former Trooper Proctor and Sergeant Uri Buchanan. What does that have to do with disqualifying me? He talks about actions by Sergeant Buchanan taken after he left the Norfolk District Attorney's Office in support of a legal civil dispute between Ms. Reed and the alleged victims in this case. That has nothing to do with whether I should be disqualified. We've talked about my voluntary withdrawal from the indictments concerning Ms. Gattani. And if Your Honor would take a look at page 6, where we have bullet points. All right. The first bullet point is absolutely relevant, and that's what we've talked about, that I'm being sued for intentional misconduct by Ms. Gattani. And we hear that Lieutenant Tully is being sued by Ms. Gattani. So what? That Detective Tully has been sued by Karen Reed. What's that got to do with the price of beans, as they say? That there were disciplinary proceedings against Lieutenant Tully.
It might be relevant on cross, you'd agree?
Oh, yeah, it might have some relevance on cross, but what has it to do with disqualifying me, Your Honor? They weren't disciplinary proceedings
Fair point.
against me. We hear that Ms. Reed is suing Sergeant Buchanan. Well, good luck to Ms. Reed, but what has it to do with disqualifying me in this case? We hear that Buchanan was disciplined. That Proctor has been sued by Ms. Reed. That Proctor has had disparaging text about Ms. Reed. There are two things that the upcoming case should not be about, Your Honor, and I'm sorry I'm losing my voice here, excuse me. One, it should not be a trial of the case that has been null pros concerning Ms. Gattani. And two, it should not be a retrial of the Karen Reed case. None of this stuff is relevant. It Kearney's testimony will undermine the credibility of Detective Lieutenant Tully and Ms. McCabe, which will subject her to cross-examination by Mr. Cosgrove. Now, let's look specifically, if I can skip ahead in the memorandum. The argument that's been made a little later on in the memorandum, in which Your Honor has heard again today.
Come on, let's go. That's why I got it sped up. He
And I'm
he
looking
can't
now at
speed
page
it up.
16, Your Honor, the first full paragraph.
Just think if it wasn't
Ms.
sped
Gattani
up.
will testify that Detective Lieutenant Tully intentionally mishandled her cell phone by tampering with and or deleting its contents. Detective Lieutenant Tully will deny this. Mr. Cosgrove has accepted Detective Lieutenant Tully's explanation without any further investigation. Well, I don't know how the defense knows that I've accepted Detective Lieutenant Tully's explanation without any further investigation. But let's put this on a timeline. It has been the contention of the defense from the start of the case that certain items were missing from the download of Ms. Gattani's cell phone. And their explanation is that must be because Detective Lieutenant Tully deleted it.
Do we have an order to increase the speed? The answer is yes. I still move that the 1.35 is not enough. So we're going to 1.4. We can slow it down when somebody else comes on.
I responded to that. Ms. Gattani is a latecomer to this discussion. She is only now, in the form of either public statements or representations by the defense as to her new position, suggested that this is because Detective Lieutenant Tully tampered with it or deleted its contents. By the way, I don't know how she would know that because she was not there.
So what they're saying is there's text messages between her and Tully in reference to the domestic thing that was happening with them. And that when Cosgrove turned over those text messages to Aidan thing, some text messages were missing. But Lindsay has them, or they're missing from the download of her phone. But she knows that something just fell down from my chair. She knows that there's some text messages missing. That's what he's talking about.
During the download of her cell phone and the transfer of it. But at any rate, my response as to what happened to the cell phone occurred before Ms. Gattani made any of these statements whatsoever. I don't know how it can be that I have been siding with Detective Lieutenant Tully over Ms. Gattani. I haven't seen an affidavit from Ms. Gattani. I haven't seen anything from Ms. Gattani other than hearsay, which is just a representation. And certainly, but let's assume that I do, as they put it, side with Detective Lieutenant Tully in cross-examining Ms. Gattani and in the closing argument. What does that have to do with defending my position in the Middlesex case, and how is it relevant, and how would it even be introduced? I have no idea. Let me back up and make a couple of other points. I want to turn to the legal argument, say a little bit about the law, and I suspect Your Honor has probably already looked at the two cases cited by Mr. Betterow, Commonwealth versus Dunlap, and the other case is named USD Health, which involves a complicated civil action involving the Church of Scientology and others. The first thing to say about these cases is they're Pennsylvania cases, not Massachusetts cases. So at best, I would say they are persuasive authority, not binding authority.
I don't think Ms. Betterow contends otherwise.
The second thing I would say is that they are both opinions in which the court declined to rule for the defense on the conflict of interest argument. In the first case, Dunlap,
the decision of the Superior Court judge was affirmed by an equally divided court. The dissenting justices characterized the other side as the majority, but the opinion itself says that the appellate court was equally divided. So I'm not sure if it's even good as dicta. It seems to me it has no precedential value at all, but if it does have precedential value, it was a ruling in favor of the Commonwealth. And what were the facts? In a sentence from the dissent, that is, those who believe there was a conflict of interest, the district attorney who prosecuted this case also represented the victim in a civil suit arising out of the same transaction. That is a mile away. That is a stadium away. That is a continent away from the facts in this case. I am certainly not representing Ms. Kearney in a civil suit arising out of the events that bring the defendant into court. Now let's take a look at US v. Health, or Health, I guess it is, which is the federal case.
By the way, I think I might have mentioned earlier that this judge took over for Cosgrove. How come he's not interrupting Cosgrove? He interrupted Mr. Betterow quite a few times, and now he's just letting him just sit there and just state his case.
That does have some interesting parallels to this case. According to the decision, and I apologize for not having the pin sites, but I think Your Honor will readily find them, the defendants contended on appeal that they were denied due process because two prosecutors were defendants in a civil action filed by the Church of Scientology 10 days after the events that went down in this particular case. And they alleged, and the events that went down were a search of the Scientology's office in Los Angeles, and they alleged that the raids were conducted in bad faith with the intention of violating Scientology's constitutional rights. You can look back at the memos filed by the defense, and the contention they're trying to make, but one of them is that this is a bad faith prosecution. So that applies here. What is different here is the civil suit apparently precedes the raid that the prosecutors make in the defense office in the Church of Scientology. Here, there's nothing like that. The events that the defendant was charged with in this case occur before any involvement by Ms. Kearney, before any involvement, by that matter, with me. And those issues are pretty well set, and they have consistently been followed through. Now, here's another similarity between Height and the current case. I'll just read a sentence or two. The government contends that prosecutors cannot be disqualified when sued by a defendant, because defendants could then remove whichever prosecutor they please simply by suing him. Now, of course, the defendant isn't actually suing me here. He's simply seeking to profit from a witness suing me. But certainly a suit by the defendant would be a much more direct potential conflict. I have not gone so far as to represent to the court that I cannot be disqualified when sued by a defendant or by Ms. Kearney. I think in fairness, the court can look at it. But the federal court, the argument was that any suit complaining of an action taken in a prosecutor's quasi-judicial capacity would be frivolous and non-disqualifying because he enjoys absolute immunity as a prosecutor, cite to a U.S. Supreme Court case. I believe as Your Honor reads through, we'll find that the court in Height pretty much bought that argument. And they go on to say that appellants have made no credible claim of actual prejudice based on the prosecutor's alleged pecuniary or personal interest in the outcome of this prosecution. I certainly have no pecuniary interest in the outcome of this prosecution. I have no personal interest in the outcome of this prosecution. And nothing in this prosecution is going to affect anything that's going on in Middlesex.
It's not Middlesex.
Worcester Superior Court, Your Honor.
Understood. Any further? From Mr. Cosgrove, sorry.
No, I'll stop at that point, Your Honor.
Mr. Betterow.
Yes, thank you, Your Honor. We might as well.
Okay, sorry. I gotta slow it down for Betterow because Betterow talks so fast you won't be able to understand him. We'll still put it at 1.25.
I'll start from the back with US v. Health, Your Honor, which is 668 Federal 2nd, 1238.
Get him, Betterow. Get him.
1981. Mr. Cosgrove has buried the lead about Health and about Dunlop. Those were appellate arguments post-conviction. Now, that is a huge distinction about a timely motion in advance, raising issues which could lead to a conflict. We all know that raising a conflict on appeal when you could have raised it before is looked at in an entirely different way. And the relevant language from Health that I would direct the court to is on page 1276, which states, given the need to promote the appearance of justice, a trial court on timely motion, to wit, like here, should disqualify a prosecutor from participating in a criminal action when he has a personal conflicting interest in a civil case. That's here.
Well, the key words there are alleging bad faith. I'm not sure that there's an allegation in those other complaints of bad faith. There's an allegation he violated the statute. I'm not sure where it talks about bad faith.
Sued him for intentional infliction of emotional distress,
Negligent
coercion.
infliction. Negligent infliction. There's a difference.
She sued for intentional.
I read negligent, but I'll go on.
Respectfully, Your Honor, there are deliberate allegations of intentional misconduct in the complaint,
Right.
but that's, the court can obviously go back and one of us.
We took judicial notice. so
Exactly.
whatever
One of us is right.
I read this morning as negligent, but I could.
Don Law
One of
the
us
same
is
situation,
right.
Your Honor, it's post
And it's
conviction.
not you.
The other issue, and I want to now go back to the beginning that Mr. Cosgrove started with, he illustrates the whole problem here. He's defending himself, and I have no opinion on the merits of Ms. Gaetani's claim, okay? As a lawyer, I sympathize. But he started by telling you that this case is going to get dismissed, and all I did was turn over this. He is illustrating front and center his personal interest, that Gaetani is accusing him of things he didn't do. And the conflict, the personal interest, isn't the outcome.
He's not accusing things he didn't do. He acknowledges doing.
But he's justifying it and saying she's trying to do this, she's not credible. The point is this: the personal interest for Mr. Cosgrove is not whether he was wrongfully sued or whether it has any merit. His good name has been attacked. And like anyone else, he has an absolute right and a personal interest in defending himself. And again, the proper forum to do that is not while prosecuting a case in which his accuser is a witness, his co-defendant is a witness, and Ms. Gaetani is going to probably impeach, assuming she's allowed to, their star witness, Ms. McCabe. When someone's integrity is attacked, they have a personal interest, especially someone as credentialed and respected as Mr. Cosgrove. We all understand that as lawyers and judges, but that doesn't mean you get to prosecute the case. That's for you to decide, obviously. And we're talking about an appearance. If this looks terrible, which leads to my next point. Mr. Cosgrove went through all of these allegations in our papers about, Proctor had this, Tully's been sanctioned, Buchanan, it's literally aligned with Jennifer McCabe, which we wrote about, supporting her. Buchanan was a witness in this case too, and part of the investigation.
But not anymore.
No, but the point is this: he is looking at this in a vacuum. The public must have confidence. Part of the analysis of a conflict of interest is the first sentence of the brief that he just cited from, is that the public must have confidence in the criminal justice system. And this latest conflict is a pile on conflict after conflict after conflict in this case. And if the cherry on the sundae...
But let's just, let me slow down, because we're conflating two different issues. I'll agree with it. There's all sorts of issues that have developed over the course of these interrelated prosecutions. Mr. Cosgrove's role, though, is a latecomer and really had nothing to do with any of these other issues. So I can't sit and say I impute all of those other things to Mr. Cosgrove. And therefore, if we look at that mass of problems that have developed, he's out. Because the same logic would say the next person who sits in that seat, the same argument would apply.
Let me be very clear. I'm not accusing...
I didn't take it that you were.
Fair enough.
But my point is, all of those things are conditions which are already present in this prosecution.
They are.
So really the only thing that I'm dealing with is this one issue, because the rest of those things he had nothing to do with.
Well, one of them, he had this other conflict which he voluntarily sought.
But that came out of the same exact issue.
Yes. Well, that's our point. We think it's the same conflict.
I agree with you. But what I'm trying to, the point I'm trying to draw and the distinction is, all of these other problems that arose out of the Reed prosecution, real, imagined, substantial, that's really not for me to decide, right? They're all out there, all right? And they're all going to be there no matter what. So whoever sits in that chair right there is going to have all of those problems.
Difference, I don't mean to cut you off, Your Honor.
Yeah.
The difference is that if it's not Mr. Cosgrove, the man or woman who would be sitting in that chair is not being sued by Ms. Gaetani and co-defendants with DL Tully.
That's my point. That's the only thing I have to analyze. Okay, that point.
Our point, respectfully, was that given the public's need for confidence in this case, not the Karen Reed case, that's a whole nother conversation for someone else on another day. But this case is filled with conflicts, and I don't think we can all just avert our eyes to and say, but none of that matters, but we're going to have a prosecutor now cross-examine his accuser and then say she's not credible. He also indicated, Your Honor, they're not even calling Ms. Gaetani. I can't fathom how that might happen. They use careful language. They may call her. We're the defense. We don't have to do anything. We can take a nap throughout this trial.
Understood.
And there may be such a terrible joke of a case they present that we stand up and rest. So, of course, why would any credible, serious lawyer commit a year in advance? I'm calling this witness. We're alerting Mr. Cosgrove to what we think is his conflict in the court, and we may very well do that. The last point for this, he said there's no affidavit from Ms. Kearney, or it's all just hearsay about, tampering with her phone. The best basis for that will be the posting online social media by a third party and longtime known critic of Mr. Kearney of messages which did not appear on an extraction report that we got from Tully of Gaetani's phone, and then we never got anything from Tully's phone. We got screenshots of what he claimed were messages. That's the basis for that. Thank you.
Okay, fair enough. All right, so here's what we'll do. We're going to set another date. Let me talk about this. Mr. Brady, when we selected we penciled in the trial date, I gave you a very long date. Longer than I wanted. Your schedule, has it changed? Can we get this thing done earlier? Assuming it's alive?
Judge, it's probably gotten worse.
All right, well, we're not moving the case back. That trial date's not going to go backwards.
Okay.
This is a 2023 case. It's 2026. It's not going backwards. If anything, it's going to move forward. So don't.
I know you'll relate to this, Judge. I have the usual
I
slate
know.
of like fall murder cases.
I get it. I get it. But this one's an old one, and it's set. So I was going to try to move you forward. But if you tell me that can't happen, then that can't happen.
I'm sorry.
All right, but understood. This court is willing to take this case much faster than the current schedule.
Get that, Your Honor. We do have a few other pretrial matters to address. Your Honor mentioned the motion to dismiss. Maybe we should schedule that.
What we're gonna do is this. I'm gonna take this under advisement. We're gonna pick a date right now. And either we do a motion to dismiss that day, or we're on for appearance of new counsel that day. All right, one or the other. We're gonna know. I'll get you a decision beforehand. Now, I am open to the idea that if I accept there's a conflict here, I haven't made that determination yet, but if I accept there's a conflict, I'm open to the idea that it's resolvable by having someone else step in and cross-examine her. I think that solves all of the issues. So that might be the easy way here, so everybody can get this thing moving and have this trial, which all parties seem to desire.
So just on that point, I appreciate you kind of reflecting your thought process. But, even if counsel stays on the case, but doesn't actually do the questioning, it still remains that there's a conflicted counsel on the case, and the
Mr.
jury
Bradley,
ought to know
you and I both know
that
that
interest.
Mr. Bradley, you and I both know this happens with some frequency, and we work our way around it. All right? The jury's concentration in this case is on the events of the case. Now, Ms. McCabe's credibility, I expect to be a robust cross-examination based on all the information that you've gathered. And if it's appropriate to bring in an extrinsic witness, and generally, as you're well aware, it's not. If it's appropriate to have an extrinsic witness on that issue, then we'll take that as we go. But Mr. Cosgrove raises a reasonably good point that, there's been some recent case law talking about, the police can't create their own exigency. And to some extent, the defendant has created his own exigency here because, in fact, the plaintiff in that case is suing because the contents of her phone were put on the internet. The defendant did that. So there is some, you got to be fair to both sides here and say this is something which only happened because steps taken by the
Judge
defendant.
Jason.
Well, Judge, I don't want our lack of response to that to be perceived as a acknowledgement. I don't want to address that.
I'm basing that
For a ton
simply,
of obvious reasons.
I'm basing that simply on what I read in her complaint, not on anything that's been represented to me today.
Right, exactly. And so just a couple rewinds here, judges, that the government themselves, in Lieutenant Tully's own affidavit at the time of this back in December of 23, swore in the affidavit that Ms. Catani was a witness in the matter. And so I don't think the government can do a 180 and say, oh, she's not really a witness.
Oh, she's a witness, but she was a witness at that point. They were trying to indict your client for some sort of conspiracy charge, which failed.
Right.
All right, and
But
the grand jury didn't
live and under investigation.
Well, that's another matter. I've told you I have no authority to affect that. What I do know is that was no build.
No bill.
Even worse. Okay, that was no build. So. I can't imagine a circumstance where I would allow evidence in about a no-build issue. I remain to be persuaded on that. But
So what, and just to go to the lowest hanging fruit on why Ms. Catani would be a witness, there's all sorts of screenshots and text messages, and we need these things authenticated before we use them.
I'm not necessarily saying that can't happen.
There's all sorts of reasons. Judge.
I get that, but
No one's trying to trigger a recusal. There's a lot of good reasons why she's involved in this. The government's own affidavit.
I'm not discrediting what you're saying. What I'm saying to you is, I think there's a way around this. And I don't know that a closing argument is going to change that, because the closing argument is based on what's heard at the trial, and I'd add, in this court's view, and in the proper practice, would be confined strictly to the evidence that's presented before the court. So, no, it's not going to.
I appreciate your reflections, Judge. If I could just have one moment.
Yeah.
Thank you very much. All right, that's all we have. And just,
Let's pick a date.
are you, late February, March, okay? Early March? What would you like, Your Honor?
Let's go later in March.
All right, March 27th?
Is that a Friday? Fridays are generally best.
I can do that. It is a Friday.
Do it on a Friday.
Thank you.
I don't know if we'll be in this room. I'll have to consult with the occupant who has generously lent me this room today.
I want to say one other thing, if I could,
Sure.
Your Honor. I am concerned that the protective orders that have been issued by the court have been the subject of violations. I'm not prepared to address it today, but I want to put the defense and the court on notice that I do think there's a basis for that argument, and I will plan on raising it at the next hearing.
Well, raise it first with the other side, so that they're aware of your concerns.
I will, of course.
All right. If it's not resolvable, then the court will step in. Nobody benefits by undermining the protective orders. Look, again, the way this court looks at this is that this is an important First Amendment issue, which should be decided by a jury of the defendant's peers to decide the mores of our society, whether or not this is journalistic activity or it's not journalistic activity. Let's try to focus on that, folks.
I absolutely agree with that, Your Honor.
Okay? All right. Anything else we can do today?
No, sir.
March 27th, the purpose of that hearing to be determined, but it's going to be one of those two things.
Thank you.
Thank
Okay.
you very much, Your Honor.
All right.
All right, both matters continued to March 27th, time and session.
Oh, you can't hear me. Okay. So it's bananas, right? So after this, he made this interim order. So after the hearing on the 30th, the court makes the following interim order. I think this came out today at 2 p.m. The court will defer on any ruling for the papers 110, 117 until March 13th. So 3/13, we're going to mark that. That's my birthday. We're going to mark that on our calendars to see what he's going to say. No later than March 6th, the special prosecutor Cosgrove will inform the court in writing if he intends to have an assistant special prosecutor available at trial in the event that Ms. Gattani is called to testify at trial. Footnote 1. A court reserves on any ruling as to the scope and or admissibility of any potential testimony by Ms. Gattani. Meaning he wants to limit her, but we'll get into that later. In the event that Special Prosecutor Cosgrove intends to have an assistant special prosecutor available at trial for the purposes of cross-examining Ms. Gattani, such assistant special prosecutor must file their notice of appearance with the court no later than November 23rd, 2026. And the reason for that is that they want to go to trial. Back in November, December, that's when they said they wanted to go to trial on this case. So, as you heard from the judge is basically clearly stated, hey, I'm not going to decide this case. I'm not going to be the one to rule on this. It's going to go to the jury. This is going to trial. They have a motion to dismiss coming up. I don't see how it's going to pass. I see them spinning the wheels, and I don't think it's going to come to anything. When is that supposedly going to happen? Maybe March the 27th, but we don't know for sure because we've got this arbitrary date of the 13th. So, stay tuned. He said it was a First Amendment issue. I agree. But what's going to happen? Is this going to go to trial? It looks like it's on the rails for trial. So, stay tuned. Make sure you like and subscribe if you want to hear more about the Aidan Kearney case. Again, it's intertwined with Karen Reed. Can't have one without the other. So we're going to end the stream today. Thanks for watching. We'll see you on the next one. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.